Good night to the viewers. Welcome to Legalize this 29th day of September 2024. Tonight we have an esteemed panel of attorneys from Grenada and St. Vincent to look at the important issue of obtaining title to land by adverse possession. The topic is of importance both to Grenada and to St. Vincent the Grenadines because we have similar systems for transferring land from one person to another. Both countries have a Possessory Titles Act, which facilitates obtaining title by a process through the courts after a period of adverse possession. Why is good title important? It is important so that the land can be used as security for a purchaser to obtain a loan to buy it, or for the owner of the land to obtain loans to open a business or to send children off to university. An issue has recently arisen in the courts of Grenada as to whether a person who has a deed for land and is thus recorded in the deeds and land registry as the owner of the land can approach the court to obtain a possessory title on the ground that there is a defect in his or her title arising from some transaction with the land by a previous owner, in some cases decades ago. The court seems to have said, in essence, that the purpose of the Possessory Titles Act is to allow persons who have been in adverse possession and don't have a paper title to get such title, not to correct errors in title deeds of registered owners. Before I invite the guests tonight to discuss the topic, we will show a short video, 10 minutes or so, on what is adverse possession so as to introduce the discussion. The video addresses the issue in the American context, but the law on this subject comes from England going back centuries, so it is relevant to our discussion. Before we get into the video, I would like to recognize the sponsors of the program: Jail Professional Solutions, JMFM, carrying the program live out of Canada, and Grenada Technical and Allied Workers Union, Zita.
Have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
And today our discussion is going to be about adverse possession. So what is this doctrine under which a person in possession of land owned by someone else actually could acquire title to that property? How does that happen, and why does it matter? And if you're the landowner, what can you do about it before it's too late? That's one aspect of it. There are conditions apparently under which it was once considered a good thing, adverse possession. Think of non-used farmland that's remaining vacant. Let's find an efficient use. Help us understand, what exactly is adverse possession? How does that happen?
So adverse possession is a century-old doctrine, and it is the hostile use of your property by someone else. And if they can check off certain elements, certain requirements, they can actually take over ownership of your property. This is rarely granted, but it's on the books in every state. The length of time that they have to possess varies between 5 years and 30 years. It's 10 years in Rhode Island, 20 years in Massachusetts, there's a list of requirements, and the courts jumble them a little bit. So if a layperson just picked up an adverse possession decision and the statute, they would be confused because the terms tend to be archaic and they don't mean literally what they say. So if someone is supposed to be controlling my property to the exclusion of everyone else, that doesn't mean I can't walk across the property to defeat their adverse possession. It doesn't have to be absolute exclusion. The most common way to exclude other people is to put a fence on your property to my benefit as the adverse possessor. But you have to do it in an open way that is open to the public. Actual, open, and notorious are the first three elements.
Notorious.
And it doesn't mean, it's not notorious like Alfred Hitchcock
Right.
notorious. It's notorious as in notoriety or notice.
Noted.
And it's putting the world on notice that I'm actually using your land. And that can be done in a variety of ways. It depends on the property, whether it's a woodland, that's way far from the highway, or whether it's a suburban piece of property, a commercial piece of property. Each one will be analyzed differently. But you have to take some action to show the world that you are in possession. And you don't have to give everybody notice. You can put something in the land records, and that would be constructive notice to the world. Your mortgage and your deed are available to everyone. They're in your local land records, and that's considered good notice to everyone. So that's one way to do it. Another way to do it is to make obvious improvements and to move onto the land in some respect. The case law generally clusters together actual, open, and notorious as the first requirements. Then it's got to be exclusive, as I just mentioned. Exclusive meaning I'm not letting anyone else use this in the manner an owner would use land. That doesn't mean that I'm preventing kids from kicking a ball across, or someone's dog from straying across, or someone walking on a semi-regular basis across the land. I could still maintain exclusivity even with some minor incursions by someone else, depending on what the land is. The best way to establish exclusivity is a fence or a wall. The next best way is probably signs, no trespassing. Another way of showing your adverse possession is to improve the property. Cesspool, structures, and short of physical structures, drainage, things like that, then hanging things, a hammock, items on a tree, putting furniture there, parking cars on the land is a good piece of evidence of adverse possession. Adverse possession, so we've dealt with open and notorious. Now we've dealt with exclusivity. It has to be continuous. So you have to have continuity for at least 10 years.
In every state or
Rhode Island.
In Rhode Island.
Continuity for 20 years in Massachusetts.
Okay.
Idaho, I think, is 6 years. I mean, it varies.
Okay.
And the length of time is sort of arbitrary. There's no magic period nationwide. It really depends on how property law has developed in that particular jurisdiction. So after you deal with exclusivity, continuity for 10 years, and hostile. And hostility, which is a standalone element, is not, being pugnacious. It's not, causing confrontations. It means that you are using the land in a manner inconsistent with the owner's rights. That you are asserting a claim of rights over this land that is contrary to what the owner has.
So in the occasion that this might be a good thing, namely fallow, untouched land, could suddenly be planted, which is a good use, certainly. No one would dispute that. That's clearly different, and it's clearly not what it was intended for at the time. Maybe the person wanted to.
Parking cars on your land is hostile.
Yes.
Putting claims in the land records is hostile. Planting trees is hostile. Putting in a sewer or a septic system or a drainage system, those are all hostile acts that are in conflict with your ownership rights. That's what hostility means. And the courts are still wrestling with that idea. Every fact pattern presents a slightly different wrinkle to that analysis. But again, it doesn't mean literally hostile.
Okay. So David, how do you find incidences of this happening frequently, more frequently, less frequently than?
I think it comes up more often than it should.
Okay.
I think oftentimes neighbors are the ones who end up with these types of conflicts. Sometimes someone puts a garden on somebody else's property, or they put the fence over the line. They do certain things, maybe intentionally, maybe unintentionally.
How does that make a difference? I read somewhere that sometimes it doesn't matter. I might not have known that was not on my land or was on my land. How does intentionality factor into this?
You were right that it basically doesn't. You can be black-hearted and predatory in your adverse possession, and that doesn't disqualify you. So the court is not looking into your motivation. Their property rights.
Does it?
Property rights are sacred. The only one who has superior rights to your land is the king.
Or the government?
The king.
The king, okay.
The king, the government. So our property laws descend from England.
Yes.
The king owned everything. So there would be disputes among landowners who were primarily illiterate and farmers, or raising livestock, and they couldn't, so the land records were fuzzy. So possession was the best indicator of who should own the land. If you were grazing on that land, if you were putting fences on that land, if you were using it productively, it would become yours. And that was the simple solution back then. But it is considered, even the courts have said we have to rule in favor of this adverse possessor, but we hate this doctrine. It's archaic, it's unfair, it violates people's
Okay, so there we had this video. So let me now welcome our guest tonight. And in the old tradition, we take ladies first. So I want to welcome Miss Barnwell from St. Vincent The Grenadines. She's the president of the bar. Good night, Miss Barnwell.
Good night, Mr. Layne, Mr. Lowe, Mr. Ferguson. Thanks for having me.
Very good night.
Good night, Mr. Layne.
Yes. And Ruggles, good night.
Yes, good night. Good night, moderator, and good night to the fellow panelists. I think it is a very important topic chosen for this evening, and let's hope that from the exchanges that people will better understand this law regarding adverse possession. So thank you for having me on.
So maybe we can start off with King Kong, sir. And I just want to get your take on the video, if you think it reflects, at least in a general sense, the law of adverse possession as it developed in our country, both in Grenada and St. Vincent.
Yes. Well, in a very general sense, though, the language is a bit different when we speak about ownership, adverse possession of land. It was a bit roundabout, but when we speak about adverse possession, like they said, it's open. It's open. In other words, you're not possessing the land in some kind of secret way when nobody not looking. It's open to the world. It's continuous, and it's continuous over a period of 12 years or more. It's exclusive in that you're not sharing it with some other person who claims to be the owner also. And it's so open, continuous, exclusive possession of land over a period of 12 years or more. We don't necessarily use the language like hostile. I think it comes to it's just a different state describing it in different language. But at the end of the day, it's really somebody occupying land, even though they did not have title to land. And I think it's important when we, as a start off or discussion, to draw the distinction between what we call titled ownership. And that means that the evidence of your ownership of land is a title deed, a particular document referred to as a title deed. And you may obtain that title deed from somebody who owns the land. They might either sell it to you, gift it to you, or you may inherit it from family and friends who may have left it for you under a will. Possessory title, however, is different and is based on your actual possession of the land over a period of 12 years or more. But it's not just based on bare possession, because you may be in possession with permission by the owner, or in possession being a tenant on that particular property. So that's what I wanted to say by way of introduction.
Zita, is it 12 years also in St. Vincent?
Yes, it is. It's also 12 years in St. Vincent that you have the person who, as Ruggles has said, the person who now has possession and actively occupies the land does not have paper title. There's no deed. No one gave it to him or her. And in doing so, that person dispossesses, or ultimately dispossesses the true paper title owner once that person has been in exclusive, undisturbed, continuous occupation of that land, possession of that land for 12 years or more, and that person has the requisite intention to possess the same land.
Right. Barry?
Okay. I think Ruggles made a point there which takes us back to that title to land. And this is where that recent judgment came up, title, paper, document to land. So it starts off with the statutory declaration, the old statutory declaration as we know it. And I think the clip, the words used, some of them were just, they all mean the same thing in the context of our jurisdiction. I think it was very explanatory. The hostility, the continuity, the notorious, and so on and so forth. But I think that our law, before the law came into being in 2016, and people had these...
And you talk about the Possessory Titles Act.
Possessory Titles Act,
right.
August 2016. We had this old English Limitation of Action Act, the 12-year possession, as the guy was saying, the king, the queen, the land come from times when the king owned all the land. And same thing with us as colonies. But what strikes me, and really I'm holding kind of strong to that position, that opinion, is that our Deeds and Land Registry Act, it makes the point that, look, so long as you have a title recorded there, then it's considered good title. And I'm saying that that's moving away. So I had a statutory declaration that said I'm in possession of a piece of land for the last couple of years. That's the bare. We used to call it the weakest deed that you could find, because it really doesn't hold. It's just saying that you're in possession. But thereafter, this person gives a child a gift, right? And then that child gives somebody else or sell the land to somebody else. And all that was going on over the years. It's about 20, 25 years ago, 20 years, when the land seemed to start becoming, people very conscious of the power of owning land, of having that type of security, that this issue came up. But I could go through my almost 30 years of practice, going on 30 is a long time, that a lot of people were using that as security for loans. And it's only when the banks...
And that, by that you mean a statutory declaration?
A statutory declaration, the one that...
Okay, so before we go, tell us what is a statutory declaration?
Well, a statutory declaration is a bare document that you've been in possession, possession, right? You've been using a piece of land that is, you don't have what we know as the title deed, you know? It wasn't bought from, you didn't buy it from somebody else. It wasn't gifted to you. And interestingly enough, you know, Elaine, what do you call you, ache, you know? Is that these lands, so it wasn't gifted to you. But what the interesting thing comes in, that this was family land. This is where another side of this story comes in, you know. Family land. For example, in Calavini here where I live, most of these lands here, these acre and a half, and my family is one of them, got these lands from the Calavini estate. Right? And my great-grandfather and so on being in possession of these lands and so on, he came down the road. And they never had a title. He couldn't find anything for it. So now when you come to tell me that that is adverse possession, is another story. But the statutory declaration, I know it is a document that you get somebody who knows you in the community to just say, I know John Jones. That I am so-and-so from here, I know John Jones. He has been in possession of this land for a number of years. I have never known anyone to ever disturb in possession, you know, etc., etc. A very simple document. You see some of them is just 1 page or 3 paragraphs. Some is like 3 pages long. And then
they swear to it.
Yeah, they swear to it. They go to the registry and they swear to it. You get it cleared for taxes in the Inland Revenue Department, you know, the whole process. And then you record it in the Deeds and Land Registry. And then you have that. You have that. Now, there was this other qualification to it at one time. That is just like they say a will that is 60 years old is good title. You know what I mean? So they used to use this, well, it was kind of common. You see, it was neither here nor there. The thing wasn't that tight. Like several financial institutions will take it, depend on who, and others just won't take it. But it was not challenged in the way that it has become to be challenged.
It's been challenged now.
Exactly. I don't know. I hope that explanation.
Yes. But Ruggles, there was a decision law that which basically said that a statutory declaration, it said something about a statutory declaration and the issue of title.
Yes, and that was, I believe, a 2009 judgment or thereabout by Justice Layne, as he then was High Court judge, and it was a matter out of Carriacou. And in that matter, it was the claimants producing a statutory declaration saying, I own the land, I have a statutory declaration. And it was expressed probably for the first time in the language in which it was expressed by Justice Layne, that a statutory declaration is not a document of title reflecting ownership of land. As Ferry indicated, it basically says somebody in the community declaring, I know X to be in possession of this land for a period upward of 12 years. I don't know anybody challenging him for that land. He's occupying the land as his own. he has been treating the land as his own, and I do so declare. And then that document is registered. The problem with that is that nobody knows when such a document is registered, because you register it in the Deeds and Land Registry, and maybe in the next 5 or 6 years, somebody searching title in relation to that land and bounce up a statutory declaration, because there was no requirement that you give notice to anybody. So, but that is, I suppose, we'll touch on that. But the reality is, before the Possessory Titles Act came into effect in 2016, what people used was statutory declarations. In other words, if you didn't have a good title deed that came from somebody, because that is what land is all about, land transactions is about transferring title from one person who owns it to another person who buys it or gets it as a gift or who inherits it. It's about the passing of title. However, if you don't have title, then you can't pass title. And part of the problem with that is, as Ferry indicated to earlier, you go for a loan, or you made in your introductory remarks, you might be in possession of land. Everybody know that your grandparents occupy that land, your family, that is family land. But if you have to go to the bank to get a loan, the bank will say that, listen, you don't have good title, and we can't use this as security for the loan. Because if you don't pay back the loan, and we have to sell this land, and you don't have good title, then nobody would buy the land. So, and I think it is important to mention at the very beginning of this program that the unregistered system of land, you have the registered system and you have the unregistered system in the region. And the only two countries in the entire Caribbean that operate solely on the basis of an unregistered system of conveyancing are Grenada and St. Vincent. And I think that's part of the reason that we have all of these challenges relating to land and title to land. Grenada and St. Vincent are the only two countries exclusively under that system.
If I may ask for the benefit of the viewers, we have a Deeds and Land Registry?
Yes, so we have a Deeds and Land Registry.
When you say unregistered system versus registered system, to the ordinary person, we have to go and register our title
right
in the Deeds and Land Registry.
Right. But it's different under what is referred to as the, just to put it in simple language, under the registered system of conveyancing, what you have is what you call a certificate of title. And every transaction related to the land is registered. If you get a mortgage, you don't have to do all these searches going back. We had to go back 60 years, up to within the last 10 years. If somebody buying land, and Ferry is in a much better position to speak on this issue than myself, but you have to go back, you have to search back for 60 years to see that person has a good root of title. And then now, from that 60-year period, come up and determine whether there are any breaks in the chain of title. So yes, the documents are registered, but under the registered system, you don't have to go through that. We don't have to do 60 years now. It's now 30 years. There was an amendment within the last 10 years or so. So it's only 30 years we go back. But there is guaranteed title under the certificates of title, where everything is recorded with respect to that title. So you don't have all these searches and everything to do.
Under the registered system, you see it, there will be a single document which acts as a mirror for all the transactions related to that land. So you have to go back and look to see for every single deed. You just look at this single document, A, and that this single document is guaranteed as valid by the state.
Exactly.
So the state says it's a valid document, you can rely on it. But
Yes.
as we have our system now, basically anybody can go and record a deed.
Yes.
Very simple.
Yes.
You can record your statutory declaration. And if somebody now is doing a transaction with regard to that land, they have to go back previously 60 years to see every piece of paper that evidence a transaction with that land, and today they have to do it for 30 years.
And that's a nightmare. Yes. And that's a nightmare. So under the certificate of title, the registered system, as it is said, it evidences indefeasible ownership of land. That says, in effect, that person owns the land. You don't go behind that title because once you have it, that is so.
Okay.
So wait. Are we saying in the countries that have the registered system, adverse possession as a procedure doesn't really exist, or it still exists?
Sorry.
No. I mean, I just asking. I mean, because the system is so secured in terms of registered, it's a recorded system. Right?
Yes.
Record title.
Yes.
But
go ahead.
Go ahead, Lowe.
No.
I mean, I was intrigued by the question because for me, I think the Possessory Titles Act, in a sense, it doesn't matter whether you have an unregistered or registered system. What it's simply saying is that if someone leaves land and I occupy it for 12 continuous years undisturbed, without anyone giving me permission in any form, it matters not if the system is registered or unregistered. The act is saying that I can possess that land and I can therefore make an application based on the procedure outlined in the act to gain title for that land. So it's a formality. I would think that what is registered or not is a formality make over ease, because as Mr. Layne says, or I think Mr. Ferguson says, I think it's Mr. Ferguson says, it's a nightmare in respect of the search. For instance, for us here in St. Vincent The Grenadines, our registry, online registry, I mean, the searchers will tell you it's a nightmare when it comes to doing that search back 60 years thereabout, because some of the paper were never kept in proper conditions. They are destroyed or they are really fragile. So you have to be careful how you touch it, even though all of them is in a vault. So the other thing that I would say, though, some time ago, as a side to this conversation, is that I went to a meeting where the state here, I'm not sure if there's such a project in Grenada as well, trying to digitize the system, moving towards eventually a registered system. But that will take some time, certainly.
But what I was really want clarity on is whether in those jurisdictions where they have registered title, if there is a lot of, if a Possessory Titles Act does exist, so on, from your experience, Ruggles or Zita.
Yeah, in most of the jurisdictions, you see, you will have less an issue of possessory title on the registered system, because to take it from an unregistered system to a registered system, it's really demarcating the land in a particular way, and there are certain preconditions that you have to meet. So, for example, what most of the countries do is that there's a transition. So they run them side by side, the registered system and the unregistered system, until everything now is transferred. So, for example, Dominica and Antigua, they have been operating under the registered system for ages, since the 1980s. So a lot of the problems that we have in Grenada, you don't have similar problems, those kinds of problems in Dominica and Antigua, for example. Right? And just to add to what Zita said, well, I'm not too sure how bad it is in St. Vincent, but in Grenada, and again, Ferry deals with these things on a day-to-day basis. But part of the problem is that the searchers, the people who do title searches, can't guarantee the accuracy of the search because the physical documents you have to go through, those physical documents, where there might be a mortgage or something listed, that part of the book is missing. And therefore, you can't really guarantee because the records are in a horrible state from continued use over the years.
So I see two questions here. Cyrus Griffith is asking, how do you compare the St. Lucia system with regards to the other OECS countries? Because my understanding is that St. Lucia has a hybrid system. Can you explain for it possible? I think that's what you are addressing, Rox.
Yes.
I know about 30 years ago, the St. Lucians tried to move over.
Yes, so in St. Lucia, you have, a system is one of these, civil law jurisdictions. So you have a registered system also exists there. Grenada and St. Vincent are the only countries in the region with the fully unregistered system. So, and in St. Lucia, for example, when they were doing the transition, then you had to get all these surveys and so done, and then there will be a process for formal registration of land. There'll be notices so people can challenge, and it is something that it costs at the end of the day, but it's beneficial because this issue of land and the use of land affects your economy in a major way. So, for example, if we have people's title, everybody living on a piece of land, but if only half or less than half have what is called good title, it means that the other half can't transact any serious business. If you want to expand your house, or you want to take a loan for your child to go and study, or you want to do some kind of investment, the bank will tell you straight, or the financial institution, your title is not good. And therefore, how do you treat with it? Even in a situation where for over 100 years, as you have in Carriacou and these places, in Grenada too, but it's very profound in Carriacou and Petit Martinique, families occupying that single part of land over the years. They just don't have any title document. And that puts you at a serious disadvantage, even in advancing in life. So I think it's in that context, the Possessory Title Act and so came into being.
Jomo is asking, does possessory title exist in England? Zita, I know you're trained in England, so you could answer.
I honestly, I don't know. My memory is telling me way back then it did, because some of the cases that we have done before, but yeah. I cannot give a definitive on that. I can do a quick search.
Yeah, but it certainly existed. It certainly existed. We have, in fact, the prime authorities on possessory title came from the United Kingdom. However, it is less a problem now because they have all gone to the registered system of conveyancing. So, and so that's the difference. But we have all come from, as the gentleman in the video said, we all came from the position of the king owning all the land, the crown owning all the land throughout the ages. The situations now where you have individual ownership of land, but you have not had a proportionate transition or evolution of the land system in that period. So we basically operating, I think our Limitation of Actions Act is an 1890-something act, 1890-something in 2024 now.
1897.
Right, or thereabouts. Good.
Yeah. So if I may, from my own research, the answer regarding England, the answer is yes, you can have adverse possession of lands, even under the registered system, but then there's a process to have that interest arising from your adverse possession, where you have the registered system for that to be entered onto the certificate. So anybody who goes to visit the certificate, to look at the certificate, to examine the certificate, could see that somebody obtained an interest by adverse possession. But the process is extensive, and I think in that process, you have to notify. You have to notify the person who was last registered as owner that you are in fact engaging in that process.
Yeah.
What that system does, adverse possession as a tool in this registered system, as I understand it, is that it basically encourages people to mind their business and to look after your land. So to ensure that nobody can take possession of your land for a period of be it 12 years, 15 years, and use your land in a manner as though they were the owner of the land, because at the end of that, your title is extinguished. So I don't think very it matters whether you use a registered system or we just have a recorded system, because you can still have, acquire interest in the property by way of adverse possession. Right? But so, Ross, based on all that you've been saying, it appears to me, and I don't know what's the view of the others, that the bigger problem we're speaking about is defects in title, rather than a system where, as was being discussed in the video, where you have someone ousted the true owner and thereby being in possession of the land for a period of 12 years or more in the case of Grenada, and then going to the court to say, listen, Mr. X was the owner of the land. I have dispossessed him for a period in excess of 12 years. He no longer has title. I want a proper title. I want a title. I want a document showing that I am the owner of this land. It appears to me that that is less the issue. The greater issue is what you spoke of, where lands were handed down from generation to generation, maybe not properly handed down. You can't find this piece of paper, you can't find that piece of paper because of the system that we have, being the recorded system. And therefore, you need to have a system whereby that can be remedied. Am I making sense here?
Yes. Well, actually, a way to put it with a registered owner, if you want to, if under a registered system, if the certificate of title says Ferron Lowe is the owner of X piece of land, then Ferron Lowe, that is evidence that Ferron Lowe has an indefeasible title to that land. He is the owner. Under a registered system, every time there's a transaction, and in this century too, it was changed from 60 years to 30 years. You have to go back and actually determine, notwithstanding the fact that you might have a title deed recorded, you are required to search to make sure that that person is actually the owner. And then when people do title searches, they might find the land was left 20 years ago for 5 people, but only 4 people signed when the deed was. So you have a deed, but at that time, 20 years ago, only 4 of the 5 people signed. So there is a defect in that title, in the chain of title, that you have to correct, going back all the way. So as I say, it's a nightmare system. And it is not just about, in my respectful view, it's not just about possessory title and the issues concerning possessory title. Our land system needs to fundamentally change. And to fundamentally change it, we have to move from a registered system, and that would be an investment from an unregistered system to a registered system of conveyancing as a starting point. So we wouldn't have all of these problems that we currently face. Until we do so, we'll be simply applying plasters to sores as they arise.
Right. So Kyle said crew. I hope I have that pronunciation right. They say that the idea is that land is a public good and should be used. I think he's saying that's one of the arguments in favor of adverse possession. And then he goes on to say one shouldn't be able to hold land without using it. And then he says, so it is a matter of balancing the interests of the landowner in keeping ownership of the land and the interests of society in having land to be utilized and not simply hold it. So I guess he will say for those in cases where you have large plots of land, because in the video that didn't come out, but it was addressed in the entire video. One of the, in fact, at the introduction of the video, they said at one time it was considered something good because you had situations where you wanted to encourage people to basically utilize land. I think that's what Kyle is saying. But then we have this situation here, which I think many people raise, because you may have a typical situation of somebody being overseas, England, Canada, the United States, typically so. They save money and they may buy a piece of land and they put down their land there, basically leave their land there with the intention of coming back in 15, 20, 30 years to build a house. Yeah? And in that 15, 20, 30 years, you may have a situation where they're out in America, they're out in England, they're not minding their business. Well, I shouldn't say they're not minding their business. They're not able to mind their business from there. Somebody occupies the land. That's morally a different situation from a situation where, as in the old days, and maybe still now, you have abandoned lands, as the guy said, people holding lands to get the highest price. I don't know how you look at it.
Yeah, I just want to make a quick point here about the possession, and as you made the point about the occupation of land. When you have title to land or title deed, you are deemed to be in possession. So you are not, you don't need to physically possess it. Once it's yours and you have a title deed, you are deemed to be in possession. Under possessory title now, in order to establish possessory title, that you are entitled to a certificate of possessory title, or even under the old system of adverse possession, you must occupy the land. If you ain't occupied, and that's the difference between the paper title holder, who is deemed to be in possession, and the person who has to occupy it to establish evidentially that he or she has been in possession.
So if you have a paper title, are you saying that it is not possible to lose the land?
Well, it's possible to lose it if somebody then go on that land, and there's a principle in law which says this: if you sit on your rights, you will lose it. So even though you own it, and let's say somebody go on a place and build a wall house on it and fence the property, and you're in check on that, and then 15 years later, or you might have seen the person and you didn't do nothing about it. And 15 years later, you decide, well, listen, I don't want this house on my land. And the person who builds the house says, well, I've been here for 12 years or more. I'm in adverse possession of this land, even though I don't have a title to it as you have. But your title can be defeated if a person establishes that he or she is in adverse possession of that particular plot of land.
Yes, so that's why I was raising the question in terms of the circumstance where you may have somebody out in England and they buy a piece of land in Grenada here to use. They get a proper title, they pay the money for it, they get a proper title. You're saying that it is possible if somebody else goes on that land and does certain things on that land, for a period in excess of 12 years, you are saying that they could lose ownership of the land.
Yes, so that's what possessory title and adverse possession is all about. You
Right.
can lose it. Yes.
Yeah.
If I may say though, Ake, I guess based on what the gentleman, the comment he made just now, I guess as a moral point, if I would put it that way, it's right or it's fair that if I buy land and whether or not I use the land, that in a short space of 12 years, that someone who may be able to go on the land, occupy it, say that I have built something on it, should be able to apply to the court and have title to that land. And then one can say at the same time that land is a scarce resource, and if you buy something and don't want to use it, somebody else can have better use of it. And the law says that if you don't have better use of it, don't want to use it in 12 years, then you can. I mean, I can say to myself as a landowner that I don't really like that piece of legislation. And I would say, and people who may not say, listen, well, someone who doesn't really own land, and I can see it. Maybe 12 years for me is a short space of time, honestly. Most of us say 12 years. Why can't we say 15 or 20 years if the person uses it?
You have the typical situation of many Caribbean people. They travel.
True.
Right? And they work to buy land. And many times the intention is to come back, retirement, to build a home. So in my view, the issue of fairness, that's a different factual situation from a situation where lands might not be handed down from generation to generation for a whole generation or 2 generations.
Right.
It is all use. Somebody goes on the land, develop the land, and work the land. To me, that's a completely different situation from the first one. Somebody up in England, in the coal, in America, and they basically buy the land and they work in saving so as to come back to build a retirement home. And that's typical in Grenada and in other Caribbean countries.
Well, isn't that bona fide owner? That person who bought that land has some standing before the court in terms of challenging one who has claimed adverse possession.
If what?
Isn't that the example you gave? Somebody in England bought this land before they go to left it there. Somebody adversely possessed it, built on it. The person's right is not extinguished. It's not. I mean, the owner, the previous owner, can't he still challenge that? I mean,
let Rob speak or speak to that.
Well, yeah, that's what I wanted.
Well, you can challenge, but that's why it is said that adverse possession is a shield as opposed to a sword.
Yeah.
So the challenge, the defense to the challenge will be, hey, I've been in adverse possession of this land for the last 15 years.
Yeah.
I'm sorry, even though you have title to the land, what the famous sections 4 and 27 of the Limitations of Actions Act says, listen, the adverse possession, 12 years or more, is an effective defense. And essentially what happens is that the title owner cannot move you, but the shortcoming there still is that the court is not giving you title to the land. The court is only saying in that action that the title owner can't move you. So then, and that's where the Possessory Titles Act comes in, because you have to get an express declaration from the court that you are entitled to a declaration of possessory title, so you can have what is called fee simple ownership, just like all other titled ownership, and you can take that document to the bank.
What's interesting, guys, is this. I've seen situations where there was a bona fide owner, somebody like the thing that Layne raised, and England bought this land, and that person was paying taxes and continued to pay taxes for the land. And then someone who came and took possession and got a statutory declaration started paying taxes. But here the twist, you go down there and the Inland Revenue is receiving money from two different
persons for the same land.
Over the years. You understand? Inland Revenue does not refuse money when you go to pay taxes. And so I throw that into the pot because now here comes the bona fide owner, the guy who had owned it, really has titled it, would have a point also in a court of hearing that I've continued to pay taxes for this land, notwithstanding I have not been in physical possession, but my title deed gave me ownership, very good legal ownership.
Right, but however, evidence, and a lot of people use that as evidence of ownership. It is evidence of ownership and title ownership, and you're paying taxes. But the judgments of the court have made clear over the years that the payment of taxes is not conclusive, even though the gentleman or whoever is in possession is not paying taxes. But the payment of taxes on the land can't necessarily defeat the possessory title, because possessory title depends on possession. No possession, no possessory title. So the issue of taxes, that would be evidence, but would not be decisive evidence to say because the person is paying taxes, then they can use that to defeat the adverse possession of whoever is in possession of the land at the material time.
But Rugs, wouldn't that be the same as well for the person who makes an application? Because a lot of times people who make application for possessory title would use tax payments, would say, well, listen, without showing active occupation, would say, well, I have been paying taxes for this piece of land as evidence that I am possessing it as well. So it goes both ways. Without the active occupation of the land to dispossess the person, mere paying of taxes saying that I possess this would not be conclusive of someone saying, well, this gives me a right then to qualify under the Adverse Possession Act.
Well, no. Remember, there's a difference between when we speak loosely of the Adverse Possession Act. I suspect that we're talking about the Limitation of Actions Act, which is the 1897, Ferry? The 1897 Act?
Yep.
Right. However, under the possessory title, and that's where I suppose the meat of the discussion on the relevant cases will come in. Because our possessory title, I'm not too sure Zita for years in St. Vincent, but our Possessory Titles Act defines adverse possession, and it says factual possession,
right,
for an undisturbed period of time. So the payment of taxes does not necessarily equate to factual possession. An element to satisfy is factual possession.
We're saying the same thing. We're saying the same thing. I'm basically saying that people, it's a practice here that usually people who make an application for possessory title use it as well, saying, oh, well, you're not paying taxes, this is an indication that I am possessing. So I'm agreeing with you as well that mere paying of the taxes is not conclusive of being able to satisfy the Adverse Possession Act.
Okay, so let's take a short break and to recognize JFM for carrying this program out of Canada, to recognize Jail Professional Solutions, and also to recognize TAU for the sponsorship of this program.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay. Welcome back. Marcel Belma is saying, I am subject to correction. Can persons have possessory title on Crown lands after 12 years also?
Crown land is exempted.
Crown lands are exempted. So the answer is no.
As far as I know.
Answer is no.
Okay, what is the question? Sorry.
If you can get possessory title for Crown lands after 12 years. The answer is
Well, I
no.
think under our act is 60. 12 is, you can't get the 12 is a different time period. So you have under the Limitation of Actions Act, if you're claiming against the Crown, it's 60 years. If you're claiming against a private individual, it's 12 years.
12 years.
Yes.
The Possessory Act specifically says it doesn't apply to Crown lands.
Right.
Well, that's under the Possessory Titles Act. Yes.
Yeah.
Which
Yes.
is what he's asked. Because
I think the distinction there is, well, that's what the case is. The Limitation Act gives you a shield, which you
Right.
can use against private persons after 12 years, and you can use against the Crown after 60 years.
Right. Yes.
Possessory Titles Act gives you, if you want to say, a soul, which you can only use against private persons.
private.
Right. Yes. Yes,
Because
that's correct.
I would say, because one of the requirements when we make the application for possessory title is that we have to have a letter from the chief surveyor saying that this is not Crown land.
Yes. So, to go back to that decision that prompted all of this, the decision, as I understand it, in one of the cases, it was a case where somebody who is registered as the title owner of a piece of land in Grenada and St, the Limes. So they have a deed. They got the land from their mother. The mother got it from her parents, I think. But at the time the deed with the title was passed to the mother, her father had died. So therefore, he would have required a legal person representative of the father to convey his interests to his daughter. So obviously they had separate interests in the land, the mother and father is what you would call tenants in common. But apparently what happened is that nobody signed the deed. Nobody signed the deed on behalf of the father. So as a result, that the father's interest was never transferred. And the person who now holds the deed holds the property with that defect in the title. That defect arose over 20 years ago, and it is not possible now to say, or it's extremely difficult to correct it. As I understand the decision, I don't know if that is the understanding of Ruggles and Zita and Ferry. And the judge was basically saying that the Possessory Titles Act was not passed for that, was not to correct defects in deed, was a situation if you don't have a deed, or if you have a statutory declaration, which the courts have said is not a deed, then you can come to the court to obtain a certificate from the court, a possessory title from the court, but that if you have a deed that is defective, the court can help you under the Possessory Titles Act. Based on all the discussion we have had here, because I think several persons, including Dr. Lawrence Joseph, is of the view that the law was not correctly interpreted by the judge, and in fact, he has recommended an appeal. Based on the discussions we have had here, should the Possessory Titles Act apply? Was it intended to apply to these situations and these circumstances? We start with Ferron. This experienced person in conveyance.
Before we go after that, I'll tell you something. Let me start off with, let me give you a Google here. You know, interestingly enough, I like that judgment. All right, I'm putting it straight across. You know why? It has, you know, judge made law as such, but what it has done is open up the whole avenue for discussion on this whole question of ownership to land, and bring to fore the same statutory declaration and the present Possessory Titles Act and so on, and to take Justice Layne, as he then was, decision back into focus. I don't think it's a judgment that I interestingly enough, I was telling you about my experience earlier before we started that it makes sense, you know, that if I started off with your bare statutory declaration as we know it before the passing of the act, and then that property was transferred over the years, 3-4 different owners, don't know whether it's deed or gift, and they used it, right, as security for a loan in some institutions. I cannot understand why now, after that same property is, I'm not speaking about the Barrett case in particular, but the principle I'm trying to develop here, that why that properties cannot be considered good, why that person cannot be considered to have a good title. You see? And the spin in all this, Mr. Layne and other colleagues, is that I think that the problem we're facing, what that judgment has brought into fore, is the problems we have with the financial institutions, solicitors, who are demanding that they don't care if you have it for whatever amount of years. In fact, you know, that they need it to be rectified and so on. Ruggles said in the beginning, let me make one last comment, had raised a point, and it was like on all fours with the exact situation I have right now. There is a couple who bought a piece of land with a high rise for $500,000 in 2001. Okay? It seems as though that one of the beneficiaries had died right before. So there were about 6-7 people entitled to the property, his family. And one of them probably died before this transaction. And the lawyer who did the deed left that person out. You know, we're still in confusion that if somebody died before, is that person entitled to property in an estate, etc. Well, that's another story. And he left that out. This person developed that property, developed it over the years, and already today, 2001, and earlier this year, they entered into an agreement to sell that land for $1.23 million. Wow. Everything went through. The purchaser, the intended purchaser, paid the deposit, and then when he went to his bank for a loan, the bank said, defective title. They wrote to him and they copied to me, and they asked him for one of two solutions. It's either we find the relatives of that deceased person, you know, and then we apply and do a corrective conveyance, or we apply for possessory title. Well, I took what I consider to be the easier route, you understand? To apply for possessory title, because there's no way I felt a judge would refuse that application considering the facts relating to it.
But isn't the decision that we're looking at now saying that possessory title is not available in this
Exactly,
situation?
exactly. And this is where I say the banks that put a spin on this, the banks are now
It's just
demanding.
the banks or the advisors.
When I say the banks, the advisors, the legal advisors, right? And to use this term, the very hard line on it, right? Very hard line, even when there's, a line of evidence to show that, look, transaction that happened here. These people got a loan from a credit union 5 years ago. Then they get a deed for a second mortgage. They have a kid in university that they get that mortgage for to support them and so on and so forth. No way. It's a hard way to. And let me make this last point. I said the one before was the last one. I think what is missing here is a failure to understand the socio-cultural basis of this society. The cultural thing is that, we really have to understand that. And you know why I'm making that point too? Is the cost involved when you got to go for this possessory title. You're talking about poor people, right? Who have a piece of land and really already they have to pay lawyers' fee. And then you're saying to them that is to get it. And then now you got to go and get a possessory title, which is pretty costly because the procedure is long and it could be very daunting at times. It's difficult. So I like the judgment in that it opens up, not the floodgate, but it opens up for debate. And it brings us to the situation, not just we have to amend the Possessory Titles Act, but we have to start looking back. Because Mr. Layne, this whole question, and Rose made a point in passing, this question that when the government amended and said if you have property for 30 years, then you have a good title. I think you and I had this discussion already, and you were saying that does not amend the Conveyance and Law of Property Act. And I am arguing that it does. It's an act of parliament. Let's stop there.
Yeah. So just to get you clear, it's not that you're agreeing the decision. What you like is that it has stimulated debate.
I think it has stimulated discussion.
All right.
Yes.
Okay, good.
Yeah.
All right. Zita?
But it's a bold decision too.
It is, okay.
Okay, so I'm sorry, did you call on my name?
I did.
Okay, right. So I will say this though, when I read it for the first time, up until my discussion with you earlier today, I totally agreed with it. I thought to myself that the Possessory Titles Act is quite clear in the requirements that one has to satisfy in order to get a certificate of title that you're free, simple owner of the land. It says that you have to you're dispossessing someone. Now, if according to the facts of the case that was given, wherein the person already had a paper title, but the paper title was defect. I think there were two scenarios given on the two different types of defect. Let's say that we're going to go with the one where it is, as Ferron said earlier, where the person had mortgaged the property 3 times before. And now the third institution, I would assume is a different institution, because if the same institution had mortgaged the property 3 times before, what at this point if the same institution would say, oh, by the way, although we have given you a mortgage 3 times before, we want to change our minds now. This is a different institution that has done the search and whatever reason says, the title is defective. Now, I don't know the period upon which they've had these 3 mortgages, but let's just say it's over 20 years, it's 10 years. Why then can't you say that that person already has good title? Let's talk about the other scenario where it is that there's no mortgage on that property and no one has challenged it. And I think it was one where the administrator had not signed. Might be the same case, administrator had not signed the deed. There's no issue with it. If it is that the court is saying, which I agree with to the extent that the requirements of the possessory title is clear, the requirements are clear, and I do not satisfy it because I am not dispossessing someone of that land, what then is the remedy that the court is providing for me to correct that? I didn't get it. There's nothing fraudulent about it. The only thing is that there was a signature that is not there that has to be there. And that's all that is wrong with this. And I've had this property in my possession for God knows the 20 years, 15 years, even 10 years to 5 years. What then can I do? Can I make an application to the court seeking a declaration that I am the true title paper owner in these circumstances? Or if not, and the court is saying I can't make that type of application either for whatever reason, Possessory Titles Act is not the avenue for me to get my remedy. How then do I correct this injustice? There has to be some pathway that the court has to make for that person to make an application to correct that defect, especially when the defect is there was no signature on it, but everything else is fine with it. I didn't get the land through any improper means.
Who else could answer that? I can tell you that. Because there's other avenues in the court you could get to correct that, to remedy that situation, besides the possessory, besides the Possessory Titles Act.
Yes. Yes. Well, the judgments have generated lots of discussions. And I support the view that the judgment has to be appealed. And I think the distinction here, and there's a certain measure of sympathy, I do feel for the learned judge in delivering this this judgment, and saying, because it's easy to practically say, listen, possessory title is what even the name of the act speaks about, which is possession of land over a period of time. Defective title is a different kettle of fish. Now, remember this act. Sorry?
Are you saying that the law says adverse possession?
Right. Well, I'm going to adverse possession because I think the in essence, I mean, to put the judgment in a mouthful, as far as what I understand it to be, what the judge is saying here is, listen, the people who have applied for possessory title, they have titles, actual deeds that they have been using over an extended period of time. In some cases, they have mortgaged the property. And now a financial institution may be saying, listen, I'm not accepting it. And it tells you how arbitrary our system is, the unregistered system, because it is based heavily on the subjective view of a bank's lawyer, for example. So you might have 3 previous mortgages given in relation to a piece of land. And when you go now the 4th time, the lawyer rejects it and finds a good reason to say, this is a defective title. Now, in my view, first and foremost, what this judgment does is to again emphasize the point that we need to change our system of conveyancing and transfer of legal title. So one, that we need to move from the unregistered system of conveyancing to the registered system of conveyancing. 1. 2, there needs to be, to clarify beyond doubt, appropriate amendments to the Possessory Titles Act to take care of the issue that was raised in these cases. Now, the learned judge relied in this judgment on a case that has been often quoted from the Court of Appeal. It's a case I refer to as the Celestine case. It's a 2010 case out of Grenada. And what that case says, in effect, is that if you are claiming title to land as of right. You are claiming through some title deed you have. You cannot, at the same time, claim possessory title. That was a learning out of the judgment. So if you're saying, listen, I have a right to the land because I bought it and I have a title deed or I inherited it, then you can't come before the court and argue possession, adverse possession in the same mouthful. I must confess, with all due respect to the Court of Appeal, that since 2010, I have disagreed with that judgment. I've used it, of course. It is the law, and the courts are bound by it. It is the law, but that judgment, in effect, again, can lead to an unjust outcome. Because in my view, you can plead like in any other case in the alternative. You can say, listen, I have a proper title. And if that, the court says no, then alternatively, you should be able to argue alternatively, well, I have been in possession of that land, treating it as my own for the last 30 years. Because based on that title, defective as it may be, I have been treating that land as mine. And therefore, you can then revert as an alternative argument. And it will be unjust if a squatter can come and use that argument of 12 years and be successful, and somebody who has stayed in the property for 40 years can't use it. So I always felt that that judgment should have been subject to, because of the importance, scrutiny by the highest court to see what they say about it. So, but the court uses it, and the lower court is bound by it. It's not, our system is that if the higher court rules, whatever principle of law is extracted from the higher court on the basis of what is referred to as stare decisis, the lower court is bound by this decision. So essentially, what Justice Acti said in this decision, listen, in Arnold Celestine case, the Court of Appeal ruled that if you have title to a piece of land and you are claiming ownership of that piece of land as of right, as opposed to by possession, then you do not have the benefit of the argument of adverse possession. So that case was referred there. Where I think the error lies in the decision is the definition of adverse possession. The Act, which came into being in 2016, defines adverse possession. No. So that is the statutory definition of adverse possession. Before that act came into effect, we had what in effect is the common law definition of adverse possession. And though it is the same concept, adverse possession, in my respectful view, the common law adverse possession is different from the statutory adverse possession. And therefore, one cannot judge the applications under the Act on the basis of the common law definition of adverse possession and on the basis of cases like the Arnold Celestine case, even though the court, as the lower court, the high court, is bound by that decision. What the Act says, sorry,
you go ahead.
Yeah, I was saying, what the Act says in for adverse possession, it says adverse possession means factual possession. Are you in fact in possession of that land? Of an exclusive and undisturbed nature. Are you sharing this land with somebody? Or are you exclusively in possession of this land? Or you and somebody else say, well, all you own it, all you're in possession of this land. An undisturbed nature. In other words, nobody is challenging your ownership to that land. So it says factual possession of an exclusive and undisturbed nature of a piece or parcel of land in Grenada for a continuous period of not less than 12 years immediately preceding the claim. Now, a fundamental distinction between the applications under the Possessory Titles Act and the common law adverse possession is, under the common law adverse possession, you use it as a shield in the event that a titled owner of land is coming after you and say, I own this piece of land, get off, I want possession of it. You then raise as a shield or defense, you can't move me because I have been in continuous, open, undisturbed, exclusive possession of this piece of land for 12 years or more, and therefore you can't move me. So it is used as a defense or a shield. Under the Possessory Titles Act, you are being invited to say, you're in factual possession of the land, you are being invited to apply to the court, not as a defense now, but to apply to the court, to ask the court to declare you on the basis of your factual possession of that land over an extended period to be now the owner of that land. So it's a different type of application. One is used as a shield. One is used simply for the court to declare you as the owner, so you can be recorded as the owner. Now, in those circumstances, in my view, it matters not whether you have a title deed over a period of time, defective or not. Because what is being said is that, listen, I have a defective title deed. However, I have been in possession of this land for 12 years or more. And I want a declaration under this act to say, based on my possession of the land over that continuous, undisturbed, factual possession of the land, I am entitled to a declaration of possessory title. Because the reality is, and Ferry used some examples, Zita used some examples, we would not fix the problem of land ownership in Grenada if you have a situation of like only about 40% of people have good title to land. And a lot of them now have titles based on a statutory declaration, which was the practice before the Possessory Titles Act came into effect in 2016. So now somebody declare that Zita is the owner of the land. Zita then has a statutory declaration. 5 years later, she passes it to Ferry as a deed now, a deed. And then 5 years later, Ferry passes it to me. Now, there have been exchanges with deeds. However, in our system, it is defective title because it is based on a statutory declaration. And a statutory declaration is not good title.
Right.
So therein lies the problem. Sorry.
Yeah, if I understand you, you're saying that you have the factual possession, undisturbed, exclusive possession for a period of continuous period of 12 years, and you have, because I think the act says that, I don't know, it is accompanied by the requisite intention to possess the said land,
Right.
the owner thereof.
Yes.
In other words, you treated the land as the owner, and you say it matters not whether you be treated it as owner because you have dispossessed somebody who had a paper title, and you be treated as an owner for a period in excess of 12 years, or whether you're being treated it as owner because you have a title which you believe to be a good title, but it turns out to be an effective title.
Right. But it was always your intention.
To possess.
And that element is also important because, as I always say with statutory declarations, even though they have no value, as the court has said, as a document of title, but from an evidentiary standpoint, in my view, what it shows is that you always had the intention to possess that land as owner of that land.
Right.
So it is evidence of that.
Our time has run out, but I just want to refer to, there's Crew, St. Crew, I hope I have it right, and he raised the issue of the Celestine Baptiste case, Celestine.
Yes, Baptiste.
The discussion. Obviously, that is kind of beyond our remit tonight. And
yes.
Also,
that is a program on its own. Yeah, I mean, I just mentioned it in passing because it was used as a basis in this case.
Backstrom holder, would this bar persons who try to claim adverse possession of so-called family lands? In other words, if you can quote-unquote get possessory title, one person who has been in possession of family lands, let's say for a period in excess of 12 years, they put up a house on the land, for example, which is the evidence of the intention to treat it as owner, whether such a person can obtain a certificate of possessory title, or if it excludes them.
Right.
He has that question. I don't think it's one that we could really discuss, but it's an interesting question that we can discuss sometime, because I know, in fact, I know of one case that is presently before the court where that is really the issue, that you can whether one family member, one family member who will have a beneficial interest with other members of his family, whether he can or she can claim possessory title to the land.
It's more difficult. It's more difficult, and that's why you must feel a certain measure of sympathy for judges who have to deal with possessory title claims. Because again, you have situations where people come, give false information to the court, and basically outsmart their relatives, and they get an order. And therefore, more and more, the evidence that you produce is critical. The quality of that evidence that shows you to be basically the one who controls that land as owner, factual possession. Even the court right now would ask for photographs, aerial photographs of the land, because you have situations where people have come to the court, nothing is happening on the land, and they say they're in possession of the land. Or they might be in possession of a little piece of the land. So the court now has moved to asking for aerial photographs of the land. And under the Possessory Titles Act, you have at least 3 affidavits that you have to file with the court. 1 from the applicant and 2 independent people, not close family. 2 independent people saying, I've known X to be in occupation of the land for such and such a period. But I think what will take care of all of this is appropriate amendments in the Act to meet these situations, because these are real situations. You have appropriate amendments. And I believe that adverse possession, the meaning of adverse possession under the statute, the 2016 statute, and adverse possession under the common law, though the concept is the same, but the definitions are different. And therefore, if you can prove factual possession, and that it's exclusive and undisturbed, then even though you have a defective title deed, you should still be entitled. You are not being asked to correct the defective deed. In a sense, you can still get an order for possessory title, but to put it beyond doubt,
The requisite intention to treat it as owner.
Right.
as owner, yes. To put it beyond doubt, you need legislative intervention, in my view.
So we have to end just about, would you recommend an appeal?
On this, certainly, because it will put in jeopardy too many people with pending applications before the courts. So many people have applications based on the same principle upon which this matter was rejected. And I say the point of law is important, and that's why I felt that the Celestine case could have gone up because of the importance and the impact it had on other applications subsequent to that ruling of the Court of Appeal. Similarly, I think this should go to the highest court for determination. Well, the highest court, as somebody pointed out to me yesterday in a discussion, the high court actually is the Court of Appeal under the Possessory Titles Act. You can't go to the Privy Council.
Yeah.
Okay, so final comments. Barry?
My final comment is just that the situation, the last scenario, we have an individual just decide to apply for possessory title of family land. And I've had those situations, and I think it's up to the lawyer and solicitor to advise some of these clients that, look, it's better you go under the estate of the previous owner. So you're coming with clean hands to declaring who are the beneficiaries and so on. So you're applying as the administrator of your dad's estate or your parents' estate. And it's safer that route, you know, to get it. So you have the consent and whatever is required to provide to the court. So, but that's very common with individuals who own family land and just decide to come for peace.
Yeah.
So that's my closing comment.
Right. I think just to briefly make some comment on the same question, it's basically what Ferron has said. Most of the time, you would have that pathway to go through estates. But there's so many different facts, because if we were to use Ruggles' application of what adverse possession means in his plain application there, then whether or not you have a paper title and whether or not it's family land, you should be able to make that successful application. If you are simply in exclusive occupation, undisturbed, whether it's family land, whether you know, whatever the case may be, based on how he has approached it, that should not stop you. Of course, it's a judge who makes that final decision as to his or her interpretation of the act itself, because the policy behind all of this has to be that you are dispossessing someone of land, not that you also own land as of right. But one last comment I want to make for clarity for Ruggles, and he can probably say that, because when he said he disagrees with the Celestine judgment, I think my understanding of it is that his disagreement is to the extent that the panel didn't have an appreciation of the pleading in the alternative, and not necessarily that the person was saying simultaneously, I am claiming or asking for you to say that I have the land as of right, at the same time claiming possessory title. What it is that if you're not agreeing with me that I have title as of right, then in the alternative, I'm seeking a declaration under the Adverse Possession Possessory Titles Act. Because I want him to clarify that that's exactly what it is he's saying.
No. Remember, Celestine came before our Possessory Titles Act.
Right.
And it has nothing to do with the panel at all. I just disagree with the reasoning in that case and the conclusion. Because what it says in effect is that if you don't have proper title, you can't plead in the alternative. Adverse possession. Now that the main plank of your argument has been defeated, which is title. Now it puts you in a very prejudicial position, where now you occupying that land for 30 years. And because you came on the basis of proper title that you believe you have, and that is defeated, then what is happening is now you can lose the benefit of that land.
Right.
So I'm saying I disagree fundamentally with the reasoning very respectfully, because I think it was a good a strong panel that heard that appeal, and I felt, and it has impacted several cases thereafter. And of course, the lower court is bound by it. The Court of Appeal actually reversed the lower court judgment in that matter. It was not the same conclusion in the lower court. So I'm just saying that we didn't have possessory title. We didn't have the Possessory Title Act at that time. We only got it in 2016. So I'm saying, if my title is bad and I've been on that land for 40 years, then I should be able to plead in the alternative, adverse possession, because I've been treating the land as my own.
Agree.
Yes. Mm-hmm.
So final comment, Jones.
Yeah, my final comment again, to really solve this problem, we have to move to a registered system of land conveyancing. We'll always be speaking about it. Since I came into the profession, the same problem everybody's talking about. And you might have improvements.
And I specifically the defective title problem.
Sorry?
The defective title problem.
Right. Well, it will take care, our system of land registration will take care of this problem of defective title 20 years ago, and you have to correct it now, and everybody dead, and there's a whole problem now to correct that. So the registered system of conveyancing, one, and secondly, so that's the first recommendation, that we move to the registered system of conveyancing. And my second recommendation is that the Possessory Titles Act be amended to say, for the avoidance of any doubt, that if you have a defective, once you're in possession, whether you have the fact that you have a defective title does not bar you from getting a proper declaration under the Possessory Titles Act, because they are the only two ways that the bank will accept your title as good. One, if you have a good legal title. Because if you have title for deeds that certain banks accept over 20 years, and then a bank come to there and say, hey, what's the one man that was supposed to sign in 1980 and he didn't sign? Your title become defective. How do you correct that? So we must have a mechanism to correct these things, and it can be corrected once we have some introduction in the law, in the amendment, to put it beyond any doubt. But in the meantime, while all that is being done, I think the decision should be appealed. It should be subject to a higher court. And it was a well-reasoned judgment in the context of where the judge was coming from. But I think one of the issues, as I said, is that distinction between the statutory definition of adverse possession and the common law definition of adverse possession. They are not the same.
Okay, so thank you to the panel. Thank you to the viewers. My own view is that, well, like Ferry, I'm happy as somebody who has an interest in the law that this case has generated a lot of debates, because I personally think that there are other problems with the Possessory Titles Act, which have not yet come before the court, but which may one day come before the court. So, for example, I may just hint one: someone who has a remainder interest, and by remainder interest I mean I may have a life interest in a property, and my daughter has the interest after I die. That may be the situation. I have just for my life, and my daughter have the interest thereafter. Now, as the law is presently, it appears that if I am dispossessed, the person who dispossessed me for a period of 12 years or more, exhibiting what the Act says, that person gets what is referred to as a fee simple, the absolute interest, not my life interest. And that's just one example. And I think that there are other issues as that. With regard to the family thing again, that's another issue we have to address because for my own research, our law is peculiar on that issue. Grenada, the Bahamas, and Jamaica share a particular, I think it's section 13 or 14 of the Limitations of Actions Act, which actually allows family members to dispossess other family members. That's something, and there's been cases I know from the Privy Council with regard to Jamaica, that provision, specific provision, Bahamas and Jamaica, and it allows that. And there are other issues concerning land. I see Kyle said crew. I don't know who he is. He has taken a very active interest in tonight's discussion. And it may be good for people who are practicing lawyers who may not be practicing lawyers, but academic lawyers to write on those issues. For example, you address the Celestine versus Baptiste. As a student of the law, I share your view on that decision. It's a pity that decision was not appealed. But I think we should encourage, I don't know if he's a young person, but to write on those things so that you don't only have people who go to the court every day, but people who address the law as academics and researchers and so on those issues. The program was very, very active tonight, and I want to thank everyone. And maybe we have to consider sometime actually continuing this discussion because land is so important to our society, to our economy, to our personal. And I want to really again say thank you. And just to end, I want to once again recognize those who sponsor this program, Gem FM, Gel Professional Solutions, and Zita.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Thank you all and good night.
Good night.
Yes, good night, and good evening, good night, listeners and viewers. Thank you.